Please rise. The Justice of the Appellate Division, Supreme Court, First Department. All persons having business with the Appellate Division join here. Give the attendance and shall be heard. Please be seated.
Good afternoon. Welcome to the Appellate Division, First Department. We have some 5 hours of argument time requested this afternoon, so please remember that we have your briefs, we have the record, we're fully familiar with the facts of your case, so ask only for the time that you will need to make your most important arguments. Also remember that when the red light goes on, if we need to, we can continue to ask questions, but you should wind down your arguments at that time. First case is People versus Larry McLoud. Five, 1, and 5. Rivera versus 712 Fifth Avenue. Five, 2, and 3. San Quentin versus C.F. Coglature is submitted. Joe T. versus Denisha T. is submitted. Merlo versus El-Cor 55. Five and 2, 5 and 3. Thank you. Shire versus Xyloware Corp. Okay. 7 and 2 and 9. Thurman versus Sullivan Properties. Do you want to submit? I'll give you 2 minutes. 2 and a submission. Thank you. Malan Banking versus Parkplace. Give you 7 and 2, 7, 2, submission, and 2. Thank you. Mayor Estates versus Century 21. Five, 2, and 5. People versus Christopher Cordero. Five and 2 and 5, thank you. Chetrit versus HPS Investment. Seven, 2, and 7. People versus William D. Scott. Submitted. Figueroa versus Relgold is submitted. First case for argument is People versus Larry McLoud.
Good afternoon, and may it please the court. I'm Jihan Rim.
Lift your voice. Raise your voice.
Oh, sorry. Good afternoon, and may it please the court. I'm Jihan Rim with the Legal Aid Society on behalf of Appellant Mr. Larry McLoud. Your Honors, this encounter was unlawful from its inception. All the officers had were low-quality, secondhand stills based off of very blurry surveillance footage and a vague description of a black man wearing a gray hat in the middle of Harlem.
Wasn't there more than just a gray hat? There was a distinctive logo on that hat.
Yes, Your Honor. There was purportedly a logo at the hat, but Your Honors have viewed the surveillance footage at this point. You can't make it out. You can't make out the suspects' faces. You can't make out the logo, and the logo was really sort of the defining physical characteristic of the suspects. Also, from the footage, and as was raised below, we
You
have
can't
no-
make out, you can make out that there is a logo, just not what the logo is.
Yes, Your Honor, but a gray hat with some sort of logo sort of just isn't enough is what we're contending here. And also, we have
What
no
about the fact that this is half a block away from where the Chase Bank, the credit cards have been found to have been used at this location, which is half a block away from where he stopped, and all the other indicators match. And then he drops the cards. He gets rid of them.
Well, I have several responses to that, Your
I'm
Honor.
sure you're going to say that he was just fumbling and he dropped the cards, but there's no evidence to that. You know, it's consistent with his abandoning the property when the officers approached. And the property was precisely that which was stolen.
Well, first off, Your Honor, I want to start off with whether there was a seizure or not as to the abandonment issue. We're contending that the test is whether a reasonable person would have felt free to go in Mr. McLoud's situation. And no one here would have felt free to go when they had more than 3 officers drive up to them along with vehicles and surround them. He may have been surprised and stumbled, but that's the prosecution's burden to sort of exclude that inference, and the prosecution failed to do that here. And even if you
So
don't,
they had a founded suspicion at that time. You're arguing that they needed a reasonable suspicion
Yes, Your Honor.
to do what they did. But I don't know that you have any case law that shows that if you have X amount of cars with, in this case it was 2, with over 3 police officers, that automatically is inappropriate, you know? And also, why wouldn't they have had a reasonable suspicion here, given all the factors that they had?
well,
Why, what, I mean, yeah, why, yeah, reasonable suspicion on level 3.
So I just want to just clarify, there isn't really a checklist for what constitutes seizure. There's different markers, you know, guns drawn, verbal commands, and here we had a sheer number of officers. We don't have maybe a specific case law pointing to just the number of officers, but the test again is whether a reasonable person would have felt free to go, and no one in his position would have felt free to go.
Why not? The police officers got out of their cars. They were wearing badges, but they didn't say, hey, you, stop, anything. They were walking toward him. They didn't have an opportunity to say anything yet before he got rid of the cards. They could have been going into a store.
I think it's very easy to know when officers are coming up to you, Your Honors, and it's very obvious when more than 3 officers and 2 cars are sort of targeting you and isolating you from your companion, that you're...
Are you saying he was the only one on the street at the time?
No, that's not what we're saying, Your Honors.
So it was his assumption that they were coming after him?
I think
No, well, but then what you're saying is that anyone in the vicinity of him should have and would have been justified in feeling the same thing as he did. Unless otherwise, you know you've done something and so you are being sought out.
I mean, Your Honors, I think first off, it's easy to know when there's a group of officers, a group of people coming up to you, no matter how.
Again, what was the difference between the pedestrians who happened to be on that street at the exact same time as your client? You said he wasn't alone on that street. So why couldn't any one of them have thought, perhaps they're coming toward me?
Well, I can't purport to.
That's my point. So that anyone on that street might have felt that. Was there anything that they said or did that was directed at your client specifically that would have warranted his assumption that they were coming for him?
A group of officers surrounded my client, at which point he dropped the cards in response to that sort of convergence and confrontation with my client. Anyone could have felt that way if the officers were sort of walking towards them, but here they were walking towards my client, who they thought was the suspect, based on sort of grainy images and the surveillance footage where you can't really make out anything. except for the fact that there were two black men at a foot action.
You say that they surrounded your client?
Yes, Your Honor.
How far from him were they when he got rid of the cards?
That's not clear from the record, Your Honors, but
So
they
you
were,
can't
they
really
were
say that-
within a sidewalk.
They were walking towards him, not
Yes.
necessarily around him when he dropped the cards.
I mean, Your Honors, they could have been in a single file at that point, and it wouldn't matter because there are multiple officers and multiple vehicles coming to confront my client. That is surrounding. No one would have felt free to go at that point.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Juliana Susu for the people. The suppression court correctly denied defendant's motion to suppress the credit cards. Contrary to my opponent's suggestions, the officers did not conduct a seizure. They did not simultaneously surround him. The officers haven't seen.
We're talking about a street, an ordinary street, where there are no other police officers. There are two people walking and two police cars with at least one of the cars had 3 officers, I think, and the other car also had officers. So there are more than 3 officers who come out. They have their badges on, and they're walking in the direction of the only people on the street. That's just one of the cars. Then there's the other car.
Well, we don't
Is that
know.
not enough to cause one to believe that they are coming for them? Did they need more than that?
We don't know for sure that the defendant and his female companion were the only ones on the streets. It was in the middle of the evening, so there was other people. But when looking
We know
at
that there
whether-
were other people?
we would assume that there were other people.
We're
There was
assuming
no-
that there are other people, okay.
When looking at whether an encounter constitutes a seizure, you're not just looking at the presence of the police officers, but particularly what the police officers are doing. And here, the officers weren't doing much. They got out of the unmarked police car in plain clothes. They had their badges visible in order to identify themselves as police, but then they started walking towards defendant at a normal pace. They didn't make any commands to defendant. They didn't give him any directions. There's nothing to suggest they had their weapons drawn on him. So nothing about this encounter would constitute a seizure. Before the officers
So
actually...
it's your position that they wouldn't need to have a level 3? It doesn't need to be a reason, they didn't need reasonable suspicion to approach him in that way? With the number of police officers and the number of cars?
For just doing that, since it would not constitute a seizure, we would say they didn't need reasonable suspicion, but based on the information, they certainly, at the very least, had a common law right of inquiry. Before they could actually reach defendant and interact with him in any way, defendant discarded a bunch of credit cards and identification cards to the ground, voluntarily abandoning them, and of course,
So what's needed to get from 2 cars with over 3 police officers to where it would have been a seizure? I mean, what, do we need to know the number of feet they were away? I mean, isn't it possible to level intimidation upon an individual without having to say, you, with the gray sweatshirt?
I don't think there was anything intimidating about this approach. Again, they weren't running towards him. They were walking at a normal pace.
So
There
if
were other people on
multiple police officers in multiple cars are approaching an individual, they have to be running to suggest intimidation or authority or anything like that?
No, when looking at this particular circumstance, one of the cars was an unmarked vehicle, so it's likely the defendant didn't even know those were police officers until they saw
Except
the
they came out
badges.
with the badges. We're talking about not
Yes.
when they were in the car, when they came out of the car approaching.
Yes, but again, you're looking at particularly what the officers are doing, not just the presence of the officers.
Did any of them have their guns drawn?
No, there's nothing in the record to suggest that they had their weapons drawn.
Did any one of them make a verbal command directed at this defendant?
No verbal commands.
And do we have to have those things in order for there to be intimidation leveled upon someone?
We don't have to have them, but it would certainly lend inference that it would be intimidating, it would constitute a seizure, but that was not present here. And when the officers saw that the victim's name was on the credit cards, they had probable cause for his arrest. If there are no further questions. We ask that you affirm. Thank you.
Your Honors, the De Boer framework is difficult to apply in even more subtle sort of situations.
Except, do you have the facts to establish the subtle situation that you're proffering?
Yes, Your Honor. The test is whether a reasonable person would have felt free to go. And that is
Yeah,
the
but
test.
we don't know
regardless-
who else was on the street. We don't know how far the police were from them. We do know that the police were in plain clothes with their badges, but didn't make any statements, didn't have any guns drawn, didn't, call the person's name out, didn't. So nothing that they were looking in his direction. I mean, we don't have any of those additional facts that might suggest that. So what you're saying is the number alone is enough.
Yes, Your Honor. We are contending that the number alone in this situation would have rendered anyone overwhelmed by the force of the presence of the police officers. And, Your Honors, nobody in this room would have felt free to leave in that situation. He was surrounded by multiple officers and multiple vehicles. And there was clearly seizure in this case and not enough for reasonable suspicion. And we asked this court to reverse the court's decision below and hold that the police did not have reasonable suspicion as to seize Mr. McLoud and suppress the evidence collected from him as a fruit of an unlawful seizure. Thank you.
Thank you. Thank you both. Rivera versus 712 Fifth Avenue.
Good afternoon. May it please the court, John Shore for plaintiff appellant. Respectfully, the lower court erred when it denied plaintiff's motion when it said there was a question of fact whether or not the ladder was an inadequate safety device and whether or not it was the proximate cause of the accident. The uncontroverted evidence was that this ladder failed. The ladder and plaintiff were struck by the ductwork that was part of the scope of plaintiff's work.
So it's your position that it was inadequate safety device, and it doesn't matter whether the ladder was hit first or the individual was hit first. He testifies that both were hit and the ladder fell. So the ladder was inadequate because it fell.
Absolutely, Your Honor. And to go one step further, in a recent case which Justice Mendez was the panel which I cited to, which distinguished one of the cases defendant relied on, Morera, Lynn v. 100 Wall Street. In that case, the plaintiff was involved with installing sheetrock, and he was holding the sheetrock. The sheetrock actually fell and struck him, not the ladder, but that precipitating event caused the ladder to move, and he fell. And this court said, in distinguishing the Morera case, where that case was some ceiling tile or whether it had to do with the scope of his work, and that only struck the plaintiff. Clearly in Lynn, that sheetrock was part of the scope of the work. Here, the ladder and plaintiff were both struck. And another interesting note in Lynn follows the line of cases of this court, Wazalewski and Marino, where putting aside what they rely on is hearsay upon hearsay, which is all in my brief I won't address. But in those cases, that wasn't hearsay, where there was testimony from the foreman and the supervisor who said, plaintiff told me that he lost his balance. That was in Lynn. In Marino and Wazalewski.
There's no witness to this accident, right?
Correct, Your Honor.
And the plaintiff here testifies that he was rendered unconscious after falling and did not regain conscious until he got to the hospital, correct?
That's what the plaintiff testified to, Your Honor, but the plaintiff already established that.
Those were friendly questions.
Right. Before he was rendered unconscious, he certainly unequivocally testified that the ladder fell and he fell, and when he was on the fourth rung of the ladder, and the impact was heavy, caused by the ductwork.
How do you distinguish the electrocution cases, the cases where someone is electrocuted? Counsel the opposing counsel says those cases are a reason to not find in favor of the plaintiff here.
Clearly different. In the Kutea case and in the, I think in the, well, that was in the Higgins case, there was totally different testimony. In Kutea and Higgins, plaintiff did not know whether or not the ladder even moved. So the court held that there was a question of fact in those cases.
And
Other
there
than-
the plaintiffs were basically shot off the ladder from the electrocution,
And-
right? Not hit by an object, and that makes them lose their balance. Different, right?
Totally different, Your Honor.
So
And
there's no falling object that caused the issue in those cases where there's electrocution.
correct. And there was nothing novel in the Kutea case. There was no change in the law. It was, as Justice Manzanet pointed out, and Your Honor, Justice Renwick, that it was caused by an electric shock, and there was no testimony that the ladder even moved. Completely different set of circumstances.
Counsel, how do you deal with the expert affidavit in this case?
As this court has dealt with on multiple occasions, in fact, Mr. Lorenz's affidavit has been rejected by this court in the Ortega case, which I cited to, and whether or not is Mr. Lorenz or another so-called expert who didn't even examine the ladder and pontificates that and speculates that, well, plaintiff was struck by the object and the ladder wasn't struck. And he puts together some, with all due respect, junk science. But let's even if we accept Mr. Lorenz's affidavit, which is completely unfounded and it's always been rejected, under the Lynn case, Mr. Lorenz, who isn't familiar with the First Department law, would then acknowledge that it is clearly a 240-1 because based on his speculative opinion, if assuming plaintiff was only struck by this object and not precipitated him to grab onto the ladder and then fall with a ladder, under the Lynn case, that's a 240-1 prima facie case warranting summary judgment in favor of plaintiff. But we don't even go that far because his affidavit is purely speculative. And I cited too many cases. Unless this panel has anything else.
Thank you.
Oh, thank you.
Good afternoon, Ian Antonoff from Kennedy's Law on behalf of defendant respondent 712 Fifth Avenue owner LP. So we're here today because plaintiff filed a summary judgment motion based on theory that an unsecured ladder was a 240 violation. And
Well, was it secured? Let's start with that. The labor law says that if you provide a worker with a ladder, and that is the piece of safety equipment you provide him to do his work, then that ladder must be secured. And if it is not, that is an automatic violation of 240-1.
I disagree that an unsecured ladder in and of itself results in a 240 violation.
If there is an injury caused by the fact that that ladder is unsecured, yes. So we have plenty of cases that have so held. We have a litany of cases that so hold.
And I think that's exactly the key, Your Honor. If that unsecured ladder was a proximate cause of the fall.
How is it not? How is it not here?
Because despite the representation that there's unequivocal testimony, plaintiff testified, I don't remember anything about the ladder falling over. He testified.
Okay,
different
let's
things.
look at the videotape, as they say. Let's look at the transcript.
Okay.
He says on 2 occasions on the first day of testimony, July 16th, without equivocation of any kind, he said that he fell and the ladder fell. He said, so what, this is the first time. So what happened was the metal that was holding it detached from the metal and hit me and the ladder, and that's when I fell. That's the first time. He says it again. I'll just read that portion of it. I don't know how they detached, but that fell on top of me and the ladder, and I fell. Twice, same thing. Then on the next day, or whatever, the September 27th, not the following day, he's asked a question, and the question is, and did the ladder fall on you after you fell to the floor? That is what he says he does not remember. He said, I don't remember anything about the ladder falling over. That is specifically with regard to whether it fell on him. That is not at all whether the object hit him and the object hit the ladder and both fell. He never equivocates as to that. And in fact, 3 questions, a mere 3 questions after that question, he's asked again, do you know if your head hit the ground first, or your back, or your arms, or your hands, or anything like that? He says, I just remembered that the duct hit my head, my left shoulder, my back, and the ladder, my body was turning, that is all that I remember. How is that an equivocation? 3 times he says the same thing. One of those times, 3 questions after what you say is an equivocation. How is that an equivocation?
So, sometimes if I can respond to that, Your Honor. So one of the times says, what he says is, this is a direct quote from the second day of testimony, I don't remember anything about the ladder falling over.
I just said that to you. I asked you a question. How does that show equivocation?
It shows equivocation because on the previous days you said the ladder did fall over. Now he's saying it didn't, and he's never said.
3 times, 3 questions after this one, the man answers that he's hit, the ladder's hit, and he falls. Completely consistent with what he says the other day. This question that you seize upon is not asking him whether he was hit or the ladder was hit before it fell. What it asked him was, did the ladder land on top of him? That is the question that he's responding to. And you are making it something else based on the transcript here that I see.
Well, I think that would...
I read the plain language right here in answer to the question.
Respectfully, I believe that is interpreting testimony that...
No, it's not interpreting. We are following the questions and the answers. They are what they are. And my esteemed colleague has read it accurately.
I'm not saying...
I've read all of this transcript. And you're asking him questions about what he knows after he hits the floor and is unconscious.
Understood.
He is unconscious. All of the questions on that page relate to what happens after he hits the floor. And he says, I don't know. Did it hit your back? I don't know, because he's unconscious.
But that's exactly the point, Your Honor. He doesn't know.
No, the questions the first time related to what happened in the happening of the accident. And he relates exactly what happened.
Let me add, there's also another question, because it was much more than 3.
Uh-huh.
And I'm looking at September 27th, line 20, question. And eventually, your body fell from the ladder until the cement floor. Is that correct?
Yes.
Case closed.
Fell from the ladder. Correct, Your Honor. Fell from the ladder. So the question here, the question of fact that...
Counsel, are you denying that it said... My colleague read
I think maybe your confusion is over the question. It's the question that is being asked that he answers. You're seizing upon the answer without the question. The question is, and did the ladder fall on you after you fell to the floor? Frankly, it doesn't matter, because he already said that the ladder fell. You're now asking him, and did it fall on you? What difference that makes in a 240, I don't know. You're already in that question, or whoever answered the question was already assuming a fact, which was that the ladder fell. And when the ladder fell, the fact that the ladder falls shows that it's not an adequate safety device under 240 sub 1. But you are seizing on the answer to the question, which is, and did the ladder fall on you after you fell to the floor?
Let's add another one.
How's he supposed to answer that?
July 16th, line 20. And did you say the ductwork also struck your ladder? Yes, it hit me and the ladder, and that's when I fell with the ladder to the floor.
Anyway, thank you, counsel. Do you have anything that you want to add? Go ahead. I'll give you some extra time to, what's your response?
Well,
I don't.
only that respondent disagrees with regard to the testimony that he gave. We think that it's interpretation of the testimony that he gave, and that the question of whether the object struck him and knocked him off the ladder is an important one. It's
Except that's not the question you asked.
Well, we believe,
Thank you, counsel.
I just want to say that we believe
I
it's
thank
directly.
you, counsel. Thank you both. How many times are you going to say the same thing?
This panel did all the rebuttal for me. Unless this panel has any other questions, I'll be more than happy to rest on my brief.
Thank you.
Thank you.
Thank you both. Merlo versus El-Cor 55.
May it please the court, my name is Scott Singer, and I'm the attorney. Oh, down? Okay, is that better? My name is Scott.
It'll be better for you. You can put it down a little further.
I'm not growing anymore. I'm the attorney for the plaintiff appellant in this matter, Mr. Merlo. There's no dispute that the plaintiff tripped on an uncovered round opening. It was a floor penetration, went through the next floor. It was about 60.
We've seen the pictures.
You've seen the pictures, and
But my question is to you, how have you established a pathway here with items stacked on both sides versus that it was an open area, as your opposing counsel suggests? How has that been established in the record?
it's established because, for one thing, there were photographs of the 7th floor and the other adjacent floors.
I looked at the photographs, and they were taken a month after the accident. And they show, looking in one direction, a clear path, a hallway. Looks like there were offices that were going to be built, except that that was a month after the accident, and no one indicates that that's the way it looked at the time of the accident. And I also see a hole that appears to be the hole, but without, and that, maybe that would be great at trial for the plaintiff to testify, yep, that's exactly how it looked the day of my accident. It was that clear path down the hall, and the same thing behind me, but that's not in the record right now.
Well, he said it was a passageway.
He did.
Yes, and there were also 2 other witnesses that said he just described it as a pathway.
But so what do we do with the opposing side? They
They
say,
lose.
they say it was an open space, that things weren't lined up as a passage. It was all over the place. So isn't it one person's testimony against another, or one party's against another?
Well, the problem with that analysis is that since there's no testimony that on the day of the accident, there wasn't a passageway there, the only conditions they...
Yes,
It was.
there's opposing testimony that it was an open area.
No, not on the day of the accident. That
The
was-
day after,
It was the day, yes, that was the day after. But remember, this was a site...
Counsel, come on. The day after, and you want to quibble with that? So unless we have evidence that after this accident, they went and cleared everything out,
Well,
right?
Well, yeah,
you know-
there was testimony that sheetrock was being moved out of the area on
The
the day of
description by your client was that the entire length of this area had supplies on either side. So when we have a witness saying that the next day they go up there and it's an open area, that sounds like an issue of fact.
because materials were being moved.
so it's your argument that they moved them, but there's nothing to establish that. At this
No.
point, it seems like one party versus another party.
Except that the daily logs confirmed that material was being moved on the...
Material
Counsel,
was
if I
being
may,
moved.
I'm sorry, go ahead.
It's okay, go.
yeah, if I may, you have the plaintiff, and then you have, I believe it was Justin Campbell, who say it was a passageway. But then you have, I believe it's Justin, and I don't know how to pronounce the,
Cloyd,
right,
I pronounce-
from LRC that says No, it was an open area. So you have two different versions. And normally what happens when you have two different versions, that's an issue of fact.
Well, I don't know what he meant by an open area, but I know that there was. I know that
Open
there was-
area, not surrounded by stacked materials. That's what he said.
Yeah, no, I know what he said, but the thing is that on the day of the accident, stuff was being moved, first of all. Second of all, on the last workday before the accident, there was a picture in the daily log of the stack material. And then there was pictures for a month prior to that showing stack materials throughout the area, and that confirmed his statement that it was a pathway, which was corroborated by Mr. Carolyn and by Mr. Campbell. So I don't think that there's a bona fide dispute. And it's not even clear if he's talking about the day after or the month after. But yes, at some point it changed, but we don't believe on the day of the accident there was any evidence that it was altered or that it was an open area. So if there's no further questions, I believe in any case, there's a case under Labor Law Section 200 and Common Law negligence that hasn't been refuted. And whether it was a passageway or not, it still was negligent leaving that opening in the floor, and that he's entitled to summary judgment on his Labor Law Section 200 claim.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court. Stephen Lau for the El-Cor defendant respondents. In this matter, there is definitely a dispute as to whether or not plaintiff's accident occurred in the pathway. Mr. Merlo gives a fantastical description of 30 feet both right and left of materials, 3.5 feet wide. However,
Well, you know, I don't know that that's so fantastical. Maybe all I am, I'm not the jury, so I can't make a determination. But we see 30 days later that there's clearly the structure for offices that could well have been the material that he was speaking about that was laying right in the perfect path for him. I'm just saying that there are two different sides. I don't see anything fantastical about it.
well, when you look at Mr. Campbell's testimony about his observations of the 7th floor where this accident happened, he says that stuff is all over the place.
That's what he
Utilities are
says.
all over the place.
But we have the plaintiff and his supervisor saying not so. There were these stacks. I mean, if 2 versus 1 would be the way we made our rulings, I'd find in favor of the plaintiff. But it's one set of facts versus another.
Correct. Yes, and just to add on Mr. Campbell's testimony, he did say it was like a maze, which is completely different from Mr. Merlot's description.
A maze doesn't sound open to me, though.
Well, that's what he...
So that kind of seems to be a contradiction in and of itself.
Because Mr. Campbell, plaintiff relied on Mr. Campbell's testimony to establish a pathway, and Mr. Campbell's testimony is somewhat inconsistent in that.
But you present it. It's all on the record.
Right.
And your client is saying it was a maze, which my colleague raises an excellent point. A maze is still a path. We've all played those games.
But not only that, the photographs are key in this situation, because the photograph was taken by Mr. Campbell and also a month later.
Now, counsel, you represent the El-Cor defendant?
Yes.
Now, your client sold the property prior to the date of the accident?
When I say El-Cor, I also mean to include WP North
Okay, just
Tower
wanna be- okay.
and LRC Construction.
Okay.
I'm sorry.
Okay.
But
Can you address the Labor Law 200 and Common Law negligence claims?
Yeah, there's absolutely no evidence that any of the El-Cor defendants created the dangerous condition alleged by the plaintiff being the whole, nor had actual or constructive notice of it. In fact, you had multiple trades working in that area. It would be Parkview, it would be Precision, and also would be LRC, their construction superintendent, who walked that floor multiple times during the day. But more importantly, at the end of the day, and plaintiff's
The
accident...
construction superintendent would know which company is the one that is cutting the holes in the cement for the piping, right?
Yes.
Okay.
And that was Parkview, the plumbing trade, installed the sleeves which created the hole which allegedly is involved in this accident. And when in doing so, they covered that hole. And that's the testimony of Mr.
Well, that is the issue, isn't it?
Well, Mr. Figueroa, who is the foreman for Parkview, testified that when they do install these Hilti sleeves, that it is covered.
And yet we have someone fall on it. So that is the issue.
Correct.
Okay.
Anything else?
No, nothing.
Thank you.
Thank you.
May it please the court, Nicholas Calabria for the respondent Precision Carpentry. I think it's pretty much been established that the 241-6 passageway issue, that there's conflicting testimony, and therefore the plaintiff should not be granted summary judgment. I would like to address the Labor Law 200 cause of action. There was so much testimony in this case about how many inspections were done on a daily basis on each of these floors. One of the reasons they were doing that because there were openings and there was an admission that people could knock it off or actually open it to do work. So there was inspections done twice a day by the two supervisors at LCR. They also said they did it in the evening, and Precision also did it in the evening. And this accident occurred on a Monday morning at 7:45, and the testimony is that there would have been 2 inspections on Friday at the end of the day. So there is no notice of this open condition. There's also some indication that Parkset, the plumber, was...
Is there an affidavit from those who actually did the inspections on Friday? Because what you usually do is insufficient evidence. So you have to actually submit an affidavit saying, this is what we do, and on this day, this is what we did. Do we have that in this record?
Yes. The testimony is from Marlon Lazama, who was the LRC supervisor, that said he, twice a day and in the evening, would do an inspection.
And that he did it on this day?
Yes, that was in the testimony in this case. And that's, again, Marlon Lazama, the person that testified. And again, there was testimony that on the date of the accident, Parkset was doing plumbing work on the 6th floor, running the pipe up into the 7th floor. So might be some indication that that work was ongoing at the time, and that's why the hole was uncovered. But that doesn't go to notice to Precision or to the GC that, you know, this gentleman that may be the plumber.
Well, if you're shoving a pipe from the 6th floor to the 7th floor, then you know it's going to pierce into the 7th floor. Wouldn't it be a good idea that before you begin that work, you check who's on the 7th floor and make sure no one is going to be in the area where you're shoving that pipe through the floor?
Yes, Your Honor, but we don't know when that was actually done in the time span. Was it done at before 7:45 in the morning when the accident occurred? There's no testimony of that. All we know from the work records is that that work occurred at some point during the day.
So you're saying that the fact that there was an uncovered hole, there's a reason for that, reason being that they were going to be putting in piping through that hole?
Possibly, or it could have been someone could have knocked it off that morning. We have no idea how that became uncovered. All we know is that twice a day there would be inspections by 2 different people from the general contractor, and at the end of the day, Precision, who was in charge of covering these and making sure they were covered, would do an inspection, and that was done at 2 o'clock every day.
So these covers are so loosely put on top of these holes that someone could inadvertently just walk by it and knock it over?
No, not at all, but during a construction project, has there ever been testimony? Or I'm not going to say that it has never been done. It could have been done. I just don't know, and no one knows. And it could have been done a minute before this accident. We don't know, and no one would have had notice of it. It's surmise at this point for a Labor Law 200 cause of action. Thank you.
Thank you.
Your Honor, as far as I know, there was no evidence that anybody actually saw covers on this hole or any of the other holes on the 7th floor. Whatever their practice was, there was no proof that it was ever done. And to me, it's not possible that with all those people inspecting and walking around the area, they wouldn't have known that condition.
Counsel, was there any evidence in the record as to how long the hole was uncovered? Any
There
information
was
about
no
that?
proof that it was ever covered. It was a 2-month-old, the concrete was poured 2 months before the accident, and then we know that as a fact. But there's no proof that it was ever covered. I haven't seen any proof that it was ever covered.
What about the issue that they were going to be putting piping through that hole that day?
Well, it's pure speculation. I mean, they knew if they were going to put it in, they should have said it. But it was not done that day.
According to
it was not in the work records that it was being done that day.
according to the testimony of was this Cloyd, there was going to be piping going. He says at the time of Mr. Merlo's accident, Parkview was in the process of installing cast iron piping from the 6th floor to the 7th floor.
He wasn't even there on the date of the accident.
He says that this work is indicated in LRC's daily job report I prepared for February 27, 2017.
Well, I don't know that he personally knew one way or the other whether work.
But that's an issue then that's got to be resolved by a jury.
Thank you, Your Honors.
Thank you all. Shire versus Xyloware Corporation.
Thank you, and good
Just a moment.
afternoon, Your Honors. James Kennedy for Defendant Appellant Xyloware. This appeal centers around a contract interpretation, a technical one that undermines the purpose of the operative agreements that, in the trial court's own words, resulted in a breach via happenstance, and as the trial court said, did not foster the intention of the parties.
So I think the trial court also, and I believe this because I was on the appeal from 2020.
Yes, Your Honor.
And in the January 2020 decision of the lower court, the court said that the succession agreements are not ambiguous about how the salary credit is supposed to work. And then the court said, was going first, one, then second. Second, Xyloware shall pay the option price for those option shares in equal weekly or biweekly installments, as the case may be, that correspond to the salary payment dates, and then emphasis added with italics, the court said, occurring during the calendar quarter following the date of that exercise of the option. Isn't that precisely what is being argued here today? Because that issue was never appealed. That was not the focus of the appeal that I sat on originally. That was with regard to tax issues. And in that decision, we said otherwise affirmed, meaning we only addressed the issue with the tax and that everything else in the decision was otherwise affirmed. So what do we do with this language that still exists, that did exist, that nobody raised in the other appeal? It wasn't appealed because presumably everybody was satisfied with that issue. What do we do with it?
Well, if I understand the court's question, you're asking me about the appealability from the judgment bringing up the initial partial summary judgment order. We could not appeal from that order because the court denied the motion for partial summary judgment. Therefore, we were not aggrieved. The finding was what it was, but we were not aggrieved by the judgment. The partial summary judgment order denied the motion for partial summary judgment, rendering a contract interpretation, but saying there was a triable issue of waiver. So
why wouldn't you, I'm sorry, maybe I'm confused. Why wouldn't you be aggrieved when that's exactly the opposite of what you wanted? Your client was using this over the year as opposed to spreading it over the quarter. Am I correct?
No, my client, yes, my client was paying.
You're the defendant, Xyloware, are you not?
My client was paying for these option shares over the course of the year and taking a salary reduction over the course of year. Did that for 3 years without objection from
And
Robert
that's exactly
Shire,
what the court said, as far as this is concerned, wasn't accurate. Because the court said here that the decision was unambiguous, that the agreement, the succession agreements were unambiguous. And I'm just quoting from what the court said.
There were two appeals, and the appeal...
I'm talking about the appeal that led to the October 2020 decision from this court.
Which held, Your Honor, now I'm confused because we had two appeals in which we prevailed. We prevailed on what we call the tax estoppel appeal, and we prevailed on what we call the modification appeal.
This is the appeal. Why don't we just use the dates? This is the appeal of the January 28th, 2020 order.
Which dealt with the tax.
Which dealt with the tax, and we reviewed that and made a decision in our October 2020 decision.
Well, the court, my point is this, the court did not pass upon in that appeal the interpretation...
Because it wasn't erased. It wasn't appealed. That's my
couldn't-
point. I don't understand how you're taking the opposite position of this. So why weren't you able to take the opposite position then? Your position then, presumably, was that it was over the year. And the courts, were you suggesting then that the appropriate reading was that it should be over 1 quarter?
No, that's the position that the plaintiff...
Exactly. That's not your position. Your position is that it should be over the year.
I mean, we say that this court accepted in the tax estoppel ruling, inherent in the tax estoppel ruling, is the recognition that the purchases were made throughout the year.
No, it's not inherent. All it said was that the plaintiff could not deny that those certificates that were memorialized in the taxes of 2015, 2016, and 2017 were made. That's all it said.
I was actually on that case. And that paragraph that you quote in your brief, just the facts that were given, that the court pulled from the case, the holding was with regard to, as my colleague has said, the number of shares, that the person was tied to the number of shares, not the valuation, not the amount, just the number. So you are providing in your brief something that you call our holding that I don't think anyone would read and say was our holding. We were simply indicating the facts that were reviewed to
Your
reach
Honor,
that.
I think we tried to make pretty clear in our reply brief that we were not saying that the court disposed of that issue at the time. What we were saying is that all parties treated the payments that were made throughout the year as, quote, amounts actually paid pursuant to Section 10 of the stockholders' agreement. And what we are permitted to do under the contract with respect to salary is we are permitted to deduct the amounts actually paid pursuant to Section 10 of the agreement. And what you have is a dichotomy, if not potentially an absurdity, where for purposes of title, Mr. and Mrs. Shire were able to declare as option share monies a full year's worth of monies and get an enormous tax break from doing that. But
Counsel,
then when
listen,
it comes to the salary
it may
credit,
be
a different standard.
That may be what Xyloware intended. Maybe, somewhere along the line, they wanted to have this tax protection. I understand that the court says that, while saying that the clear and unambiguous language is that those amounts are, it's right there in Section 10 that you just referred to. It's as clear as it could be that it's during the calendar quarter following the date of that exercise of the option. And you are spreading it over the year. And frankly, we're going to have to disagree as to what you thought the decision from this court was in October of 2020, or what you've indicated in your brief that it is.
I understand that, Your Honor, and I understand that it was our first argument because we thought it was a threshold concern, but it is a small part of the overall challenge that we're making to Justice Cohen's ruling. We think there are at least two reasonable constructions of that agreement, and it's ambiguous,
but we don't...
and that there was waiver.
Counsel, the problem, though, is that, and you said it in your opening statement, that when you referred to Judge Cohen's observation that he didn't think that this was what was intended.
Mm-hmm.
The problem is we have a holding from the court that was not appealed that the contract is unambiguous. He reaches that conclusion. We cannot, on the basis of that conclusion, then go to extrinsic evidence, which is what you would need us to do in order to reach your conclusion.
Unless, of course,
certainly
if
have
we
the-
read it, unless, of course, if we read the decision, not the decision, but the agreement, we thought it was ambiguous. But what word in here in Section 10 leads you to believe that this is ambiguous? There's nothing in Section 10 that leads to that.
Well, it's the phrase in the MEAA. It's the employment contract, which says the salary credit can be taken during each payment throughout the year of the salary in the amount actually paid pursuant to Section 10. And we believe the phrase pursuant to Section 10 of the SA is ambiguous because it's not clear that it's referencing the timing mechanism of separate Section 10. But moreover, there's this big issue of waiver.
It says Section 10.
What's that?
It says Section 10.
Well, it doesn't say.
You're saying Section 10 didn't mean Section 10?
It doesn't say Section 10.3, and there are references to the annual deductions. There are a mandatory direction that we deduct salary during every pay period. But if
You're right,
indeed
it doesn't
this was
say
so
Section
crystal clear-
10.3, it says Section 10.
It says Section 10.
And
it
Section
doesn't say
10 is the
10.3.
section that talks about over the quarter.
But the point is also here that you then have, as Justice Cohen recognized, a triable issue of waiver.
Well, yeah, counsel, I'm glad you brought that up, waiver, because
Yes, Your Honor.
There was a required writing with respect to waiver. So is there something in writing saying that there's a waiver?
Well, there is case law.
No.
Was there
No.
a written waiver?
Yeah.
Well, Justice
Because
Cohen.
let me just finish my question,
Yes, Your Honor.
because let's break it down this way. There was a requirement of written waiver in the agreement, yes or no?
To modify the contract, there was a no oral modification clause, yes.
I mean, writing, so that means a yes.
Yes.
Okay.
And
No, let's go to the next one. So my question is, since there is a written requirement, is there anything in writing indicating a waiver? That's a yes or no. It's so easy.
well, it would,
No,
yes. Yes, there are things indicating there are tax returns, and there are tax returns. There's no for consideration waiver. But if you look at Nassau Trust against Montrose.
I want to move.
And if I
You
may,
know
Your
what,
Honor,
let me-
Justice.
Let me ask
want
this
one?
question
I
instead.
don't want to speak over Your
I
Honor.
want to talk about this waiver. So, what actions did Catherine present to demonstrate waiver? Let's talk about that.
Well, first of all, she had, under the JUMAC standard, and I do want to say that Justice Cohen himself recognized that the no oral modification clause was not a bar to waiver. And that's the Nassau Trust case that Justice Bernard Meyer wrote years ago. But under JUMAC's,
No, tell
when
me
you
what
have-
she did or did not do. That's what I want to get to.
she didn't present the objection when she accepted the benefits of the deal. So what she did was she accepted the benefits of spreading the payments out over the entire year.
Counsel, didn't she
never
raise
objected.
objections all along the way by asking questions and ultimately retaining a lawyer to send a letter requesting more information about why the salary, why the payments were being spread out the way they were?
She was told by her CPA.
Did she do the things that I just referenced in my question? though?
No, Your Honor. What she did was she had a lawyer from 2013. She was told in February of 2015 that you ought to have the lawyer look at this and you ought to make objections. She waited
Prior
until
to that,
2019 to raise this
counsel,
claim.
prior to that, did she not send over emails questioning what was going on with the option shares and how the salary was being paid?
She sent one question as to whether or not it was appropriate for there to be a salary offset.
And this was while her husband was dying and suffering from a decline from Alzheimer's, right?
Her husband was indeed
Correct?
Her husband was indeed suffering
So this
from
time
Alzheimer's.
period that
Although he
you
was-
are, I'm talking, this time period when you're talking about her not doing X, Y, or Z is a time period when her husband had still been managing this business and the contracts here, and he was on a steady decline, right?
He was actually, At that time, he was not under a steady decline. He declined when he came back from Africa. He had a diagnosis of delirium. The travel was too much for him. Then he got pneumonia.
Counsel.
And then in 2015, he began to improve, and we cite to the emails and the record where he improved, and he went back to work at
Right, because so many people improve from Alzheimer's.
Counsel, I just want to go.
I'm going to let you finish these on, I've given you time, and I'm going to let you deal with the rest of waiver and rebuttal, okay?
Thank you, Your Honor.
Thank you.
Good afternoon, Your Honors. Jay Dealey from Pillsbury, Winthrop, Shaw, Pittman on behalf of plaintiff respondent Catherine Shire.
Counsel, if I may, Catherine, I just want to continue the waiver part.
Yes.
Now, she had questioned about how Robert was being paid. She had some issues with that.
Yes. Yes.
And she also indicated that she really didn't understand about how the payments were made, and she asked questions to Xyloware.
Yes, she testified that she was asking questions because she didn't have the information and didn't understand the payments.
And then Xyloware pretty much said, you know, we're just simply following the agreements. Really didn't provide her with the information. Just said, we're following the agreements here.
Well, more than that, when she asked in 2015, she was told that Robert was being paid the same salary, and that was false. And then she was told that their financial advisor, Ronald Weiner, should ask Xyloware's accountant, Mr. Wagner, for information. But when Mr. Weiner did so, Mr. Wagner said he wasn't authorized to speak to Mr. Weiner. So they were given the runaround. And eventually she submitted written questions because Xyloware asked for written questions. And the only response was, we're following the contract. So she had to follow up with a lawyer's letter in order to actually get an actual breakdown of how Xyloware was paying the salary and the insurance bonus.
Counsel, I'd like you to address the issue that counsel raised with regard to Section 10.3 and the fact that there is some ambiguity about the way that should be read with regard to the employment agreement payments.
Well, there is no ambiguity, Your Honor. The shareholders' agreement is clear that the option shares could be exercised in whole or in part up to 7 shares each year before each calendar quarter. It is clear that the option shares must be paid for in full during the following calendar quarter. And then the employment agreement says that Robert's base salary, not the insurance bonus, that's in a separate section, but they reduce that anyway. The base salary shall be reduced by but not below 0 by the amount, if any, actually paid to Robert pursuant to Section 10 of the shareholders' agreement, which includes 10.3, during such weekly or biweekly as the case may be pay period corresponding to such salary payment. So it's tying the reduction due to the payment of the option shares to the payment for the salary. And that is all supposed to happen within 1 quarter.
So that means that if I want to do 7 shares for the year and I pick January, I have to, in the last 7 days of December, give notice. And then I have to, from January, February, March, have to make sure that I pay the amounts, or whatever the transaction is, between January 1st and March 31st. Is that
Correct.
right?
If you exercise an option for all 7 shares at one
If
point.
I did that for that year. And I can only do 7 shares a year, but that's not an issue. The issue is the following quarter. The issue is the quarter
Yes.
versus the year.
Yes.
Counsel, were there any other subsections in Section 10 that would render it ambiguous based on your adversary's arguments?
No, I don't believe there's any ambiguity in Section 10 at all. If I may just, Xyloware has spoken or invoked the overall purpose of the shareholders' agreement of being able to offset the salary.
I'm glad you raised that.
But there are other purposes as well reflected in other provisions, including that Robert be promptly paid in the following quarter. And it provides a mechanism for Xyloware to exercise the shares each quarter, spreading 7 out over the course of the entire year if that's what it wanted to do.
That you're correct on. But honestly, if one had to look at this from what they might have been thinking and what Robert would have been doing if he were compos mentis, I imagine he, like his brother, would have been looking out for his kids and looking forward to this generational wealth that they were trying to build, and wouldn't have taken all of this money out. I think his brother opted not to. The issue here is that he was suffering from Alzheimer's at the time, and his wife, who's not the mother of the children or the great-grandchildren or the grandchildren, is the one who is entitled to the money.
Yes, Your Honor, and there's no evidence in the record that Robert and Henry had the same financial interests.
No,
And
there
There is
isn't.
evidence that Robert was especially concerned about providing for his wife and their daughter.
But there's no information either way. What we do know is what the terms of the agreement states.
Correct. And yes, Mrs. Shire was coping with the collapse of her husband's cognitive health, physical health as well, and trying to understand the family's finances and get everything together and trying to get information to
Is
do
there
that.
anything that Mrs. Shire would have done to contradict the waiver? The fact that she says, I never read it, I didn't know anything about it, what was in that operational agreement?
Well, she was trying to get the information. She was talking to Mr. Wiener, who was their financial advisor. She was asking the company for information, and then she sent two lawyers, two
She
letters.
never read that operative agreement?
I believe at some point, perhaps, but I think she testified that she also didn't understand it. I mean, it's quite a thick document. There are two of them, and you have to understand the interplay, and then you have to understand what Xyloware was actually doing. So you needed to put all the pieces together in order to understand what was going on, and she didn't have that information.
Anything else?
Unless Your Honors have any more questions.
I have one question. With respect to the 35% discount that Xyloware applied to the estate shares, what do you have to say about that?
Yes, so the jury found that Xyloware breached the contract when it applied the 35 discount to the estate shares and awarded plaintiff judgment $2.9 million in compensation. And so as a result, Xyloware breached the agreement when it failed to tender a promissory note that reflected the correct price of the estate shares.
No, I understand. So, but my question is, what is your response to their claim that that 35% discount applied to the estate shares as well? Beyond the fact that the jury found against them. I just want to hear your legal argument with respect to that.
Well, it doesn't apply, as the jury found. I mean, that was the issue that was tried to the jury. And
the contractual language certainly doesn't include the 35% discount with respect to that particular part of the shares, correct?
No, correct. And we were before this court previously on appeal, and the court found that there was a factual question about whether the 2014 option notice was intended to apply to subsequent years and to the estate shares. That fact issue was submitted to the jury, and they found that it was not.
Thank you.
Thank you.
Thank you. Thank you both. Oh, I'm sorry, you.
Thank you
Your
so
turn.
much, Your Honor.
sorry
With
about that.
respect to waiver, the theory that Mrs. Shire has is that Xyloware was required to pay for the option price in its entirety in a single calendar quarter after the exercise of the option. She never articulated that theory until 2019 when she made her partial summary judgment motion. She knew, however, and had all the information in front of her within 1 quarter to know that Xyloware wasn't paying for the option shares in a single calendar quarter. The option shares cost a minimum of $331,000, and she was getting 2 paychecks, and she could just total up the paychecks and see that Xyloware was spreading the payments out over a year. On March 30 of 2015, she filed tax returns in which she said to the tax department 2 things. One, she acknowledged that the option share monies were being spread out over the course of a full year, and she never complained to Xyloware that that was inappropriate. And the other thing she did is she listed a salary that was well below the salary that she now claims Bob should have received. She had in black and white in front of her in tax returns classifications made in those tax returns that she has no right to contradict under Mahoney-Buntsman, and all that information is here. That's why I would say to the court, it needs to take a macro view and look at JUMAX and say what constitutes waiver, because we have shown here that she had all the information in front of her. She didn't raise any objection. She waited, even though she was having discussions with us, she in fact deliberately said, and it's an email from May of 2016 to Mr. Wiener, her accountant, I did not tell Xyloware. I did not tell Xyloware that I'm not being paid for something that I'm supposedly selling, and she has no explanation for that. And what she's asking this court to do is to come up with this standard of waiver that all you need to say is, well, I didn't understand what my tax return said, or I didn't understand what this contract said, notwithstanding that she testified at length about her business experience internationally with Nielsen, running an office in Toronto, and was the damages witness in this case. And their sole defense to waiver is not that they didn't have the information. They say they didn't know how the allocations were being made. They didn't need to know this. They could, just by looking at the banking records, know how the allocations were being made. But they had the macro figures in front of them that they weren't being paid in a single calendar quarter, and they weren't being that the salary was being reduced by much greater than they would have thought. And the tragedy here, one of the tragedies here, is that it cost 1.5 million.
If you would just wrap it up, thank you.
This is my final point, is that Bob and Henry had the same rights. Henry, of course, testified in Xyloware's favor. This was a family business, and it wasn't in a position to allow an executive to saddle them with a $1.5 million liability, never saying, hey, you're doing this the wrong way. Thank you, Your Honor.
Thank you. Thank you both. Thurman versus Sullivan Properties.
Good afternoon, Your Honors. May it please the Court, Michael Capozzi on behalf of the defendants' appellants. The facts, based upon the facts of this case, the claims asserted by the plaintiff respondent are time barred by the 4-year statute of limitations.
You're right about the FMRA, that's time barred, but you're never time barred from determining the legal status of an apartment.
That's
And
correct.
That's what's being done here, isn't it?
Well, no, because under the facts of this and circumstances here, which are not disputed, where an apartment is previously subject to rent control, comes out of rent control, and the first tenant thereafter to take occupancy does so at a monthly rent higher than the threshold for deregulation. The only means by which to challenge that initial
What case are you relying on for that?
The Park case for one.
The what?
The Park versus the HCR. Yeah, as well as the other cases cited in our brief.
What about Olson?
Olson says the same thing, that a fair market rent to be able to challenge the initial rent of an apartment that comes out of rent control is subject to a 4-year statute of limitations to the application to challenge that. Now, what Your Honor said earlier about the
I think Olson says that he has a right to challenge the regulatory status of the apartment at any time.
Well, the challenge to the initial rent is, of course, in turn, a challenge to the regulatory status. But what I think Your Honor is referring to is a circumstance.
I'm referring to the fact that a declaration that their tenancy was subject to the rent stabilization law can be made at any time.
Correct. This apartment was never subject to rent stabilization. It was subject to rent control. And when the rent control tenant vacated in 2005, the first tenant to take occupancy did so at a rate of $25.50 per month.
Right, but we don't know whether that was appropriate.
And that's what a fair market rent appeal, that's what the application is intended, to allow the party who believes that that rent is not the fair market rent to make that challenge, to raise those issues of whether it was improperly.
Because there was no, your client did not submit the necessary paperwork to decontrol the apartment, correct? That would have put DHCR on notice that it is no longer a rent-stabilized unit.
Correct. It's not disputed that the landlord, our client, did not.
And so that creates the problem. That's why we have this problem, because had you done that, we'd be able to assess when that happened and whether that was appropriate.
But that's not that's the FMRA. We're not
there.
That's what his claims are a fair market rent appeal claim.
Counsel, if I may, why is Park, you said Park, right?
Correct.
So why is Park even relevant here? Because that was in Article 78, right? Where the DHCR denied the FMRA challenge. So I don't get it.
Well, the court and the DHCR have concurrent jurisdiction. So the plaintiff respondent in this case decided to go through the courts and make that challenge. And what Justice Gish did in Park was she explains exactly what happened here, which is that where you have an apartment that's subject to rent control, it comes out of rent control, and the first tenant thereafter takes occupancy at a rent higher than the threshold for deregulation, and the landlord does not serve that notice, that RR1, a DHCR form, which didn't happen here. And according to the statute, if that's not served, and as Justice Gish explains, there's a 4-year term, a 4-year limitations period from the date that the apartment ceased being rent controlled to file a challenge to that rent.
Right, but that's not what we have here. What we have here is plaintiff is seeking a declaration that the apartment is subject to rent stabilization and an award for an overcharge. That's what we have here.
Right, which is exactly what the claim is. That's the claim. What I think the confusion is that when an apartment is subject to rent stabilization,
I think
There's no confusion here.
I think what we're saying is that there is a distinction between the posture of a case where it's Article 78 and the posture of the case here, and that there's a distinction between Park and Olson in that respect. I don't see how Olson is the same as your position in this, because it seems like they are challenging the regulatory status.
well, it's the regulatory status flows from the challenge to the regulatory flows from the challenge to that initial regulatory. Whether or not it's an Article 78 in a DHCR proceeding or an action brought through the courts, it has the same effect. The arguments that they're raising here are the same arguments they would raise in the context of a DHCR proceeding. And there was one case I did not cite in my brief, but in 2022, in December, the Liggett case was exactly what happened here. A claim was brought.
What's the name of the case?
It's
Liggett.
I will tell you. It's Liggett, Liggett versus Lew Realty, LEW Realty, and the site is 211 AD 3rd 473. And in that case, this very court reversed Justice Getz, who denied a motion to dismiss a challenge to the rent regulatory status and the initial rent.
Thank you.
Yeah. So, thank you, Your Honor.
Thank
The court has no further questions.
Malan Banking versus Parkplace Development.
Good afternoon, Your Honors. Matt Parrott from Fried Frank. I'm counsel for the appellate lenders on this matter, which involves $174 million in defaulted mortgage financing for the construction of a condominium tower at 45 Parkplace in Tribeca. We're here on appeal of the lower court's denial of cross motions by my clients, the lenders, and by certain of the contractors for summary judgment on priority between the mortgage and the mechanic liens that were filed. We would respectfully submit that the motion court erred when it denied summary judgment on our motion and held that fact questions existed as to whether the mortgages are valid based on the date that the mortgages were executed and the date that the transaction closed.
So it's your burden to establish a prima facie, you have to establish the prima facie burden here. Is that correct? We agree with that?
Well, they've cross-moved for some
Yes, no, I understand that, but you also have a summary judgment
Correct.
motion here. So, and you have to establish the validity of the mortgage in the first instance. So how did Mr. Hamdi, I believe, is the general manager here?
Correct.
How did he do that in his affidavit?
So,
where it seems like most of the information comes out in reply, which is not a basis for a prima facie case. It has to be in the initial affidavit. So how does he do that?
So a couple of ways, Your Honor. Mr. Hamdi attached the verified complaint that was used to initiate the action, which was verified by the individual who actually executed.
But that didn't happen until reply. That's the problem, I'm saying. What happened in the affidavit? I don't want to know what happened in reply. What did you do
Well,
in the
Mr.
initial
Hamdi
affidavit?
attested that he was an employee, had reviewed the relevant records of the lender.
But he doesn't establish it by business record. He says, I know the record, something like that, but he doesn't go through the steps of a business record. I mean, this is a multi-million-dollar mortgage here, and what are we supposed to do with that?
Well, Your Honor, we would submit that his affidavit, it did include the building facility documents. It did attest that he was an employee of the company. We would submit that that's sufficient because, as he also indicated in his reply affidavit, he was at the company at the time that the loans were originated. He was involved in the transactions relating to the disbursement.
So he doesn't really have to go over the business record exception and articulate that.
No.
He just has to say, I work there, and I'm familiar with the documents. Or I work there, because he doesn't say he's got personal knowledge of this until reply.
Well, Your Honor, we would submit that the original affidavit was sufficient because he did attach the documents. He did say what his role was at the company. But there were cross motions that were submitted here as well. And so we put in they put in their opposition and their cross motion. We put in a reply and an opposition to the cross motion. And then they had a further reply where they were able to respond to Mr. Hamdi's reply affidavit. So it's not like we're dealing with a situation where they were just, sandbagged on an opposition and never had a chance to review any of this or challenge his attempts to lay a foundation, show that these documents were authentic.
So are you saying that if
opposite
they
of what
had
happened.
not filed a cross appeal, you would concede that you had not put sufficient information in your affidavit?
No,
In the first instance?
No, our position is that because the complaint was verified in the case, because he attested to what his role was with the company, because the loan documents were attached to his affidavit in the moving papers, that's sufficient to establish a foundation for those documents. When the opposition papers were filed and arguments were raised for the first time about issues relating to the timing of the execution of the mortgages and the closing, Mr. Hamdi gave further testimony, including that he was personally familiar with the project at issue in the action.
Well, the difference between the execution and the actual closing of the transaction was known to your side, obviously. So this was not a surprise. They didn't have to wait for the opposition to address that discrepancy, right?
Well, there had never been any defense raised in the matter by anyone until the opposition papers suggesting that there was some problem with the enforceability of the mortgages because of when the execution and when the closing occurred. So, of course, we wouldn't have addressed that in our initial motion papers. From our perspective, there was no issue. There is no issue because, as is set forth in Mr. Hamdi's affidavit, the documents were executed in April. They were held in escrow pending a closing. If there hadn't been a closing, the mortgages never would have been released. They never would have been effective. But what happened is there was a closing and the mortgages released simultaneous with the deed changing hands. And for that reason, there's no issue as to the enforceability of the mortgages. The other thing that the judge did, which we would submit as an error, is he considered that affidavit from Mr. Hamdi, the reply affidavit, for purposes of denying the cross motion for summary judgment, but he held that he wouldn't consider the Hamdi reply affidavit for purposes of our motion. And that was on the ground, as Your Honor pointed out, that the lower court seemed to think we should have anticipated this argument. But we would respectfully submit, as I said, that that wouldn't have been something we could have anticipated. And further, since they had cross motions, they were able to respond to everything that was stated in the reply affidavit. So certainly there wasn't nothing unfair about the way the briefing went forward. They had their opportunity. With respect to the lien law affidavit, we would submit that the motion court should be reversed. It held that there were questions of fact as to several items that were reflected in a budget that was created by the borrower in 2019, 3 years after the affidavit was prepared. The budget, though, doesn't create any kind of issues of fact, because if you look at the line items in the budget, they don't line up with the consideration figure that's in paragraph 5 of the lien law affidavit. That stated that $3 million was being paid and held aside as consideration for the BFA. And the court cited a miscellaneous closing cost adjustment, which was $3.1 million, and said that that creates a question of fact about whether or not the $3 million figure that was in paragraph 5 was materially misleading. Those are different items. It doesn't say consideration in the budget. It's not the same thing as what's listed in paragraph 5. And further, if you look at the budget, you'll see that it specifies that there's other sources of funding that are going to be used to pay the different budget items, including equity from the developer, mezzanine financing, totaling over $100 million. And so you can't compare those two things, especially when one is 3 years after the lien law affidavit was created.
Thank you.
Thank you.
Good afternoon. May it please the court. Brian Stryker from Ernstrom & Dresty for Gilbane. We are defendant, respondent, and cross-appellant. To address a few statements that were just made, the issue of the mortgage and the mortgage's validity was always an issue. Court of Appeals has said all you have to do to put an element of a prima facie case in issue is deny the allegation in the complaint. All the material allegations were denied in the complaint, respecting the mortgage, when it was delivered, when it was executed, and so forth. And we also raised the defense of failure to state a cause of action. So as Your Honor pointed out, they of course were aware of this issue with the execution date not lining up with the date that the deed was executed. And that's almost kind of evident in the record because they attach a date to every single document in the complaint except for the date of the mortgage, where they just say the mortgage was delivered. They don't say it was delivered on a particular date. They never came up with a date that they decided delivery took place until on reply. And on reply, they introduced this this document, this Exhibit 105, which is a letter dated May 13th from the bank to their closing agent saying, here's all the documents, here's all the signed documents. So we know that the bank was in possession of the mortgage, of the notes, and so forth, at least on May 13th, which is 4 days before the closing took place, or the alleged closing took place.
Counsel, can you speak to the lien law affidavit with regard to the question of fact that was raised by the trial court with regard to it being materially false, where your adversary has indicated that it's not that it was false or questions of fact, it was just line items of budget and where money was going to come from to cover certain costs?
Yes, absolutely, Your Honor. So let's start with the understanding that the lien law is there to protect the contractors. The Court of Appeals was very clear about this in Nanuet, that the whole purpose of Section 22 is there's supposed to be no secrets for the contractors. They're supposed to know exactly how much is available for the project, and all of the fees or hidden fees and consideration and so forth that may be buried, which could affect that net sum available. Here, what happened is we've got $3 million $3,045,000 is reflected as the consideration number on the affidavit. Regardless of the budget, is pointed out by Permis de Lisa, my co-defendants, that if you just analyze the building facility itself, there was upwards of $13 million in profit or interest that's supposed to be paid on this loan. And the loan actually created a mechanism whereby the lender could start charging that interest amount against the principal, which would of course reduce the net sum available to the contractors, which eventually happened. So we don't even necessarily need the budget to show the inaccuracies and the falsity of the Section 22 affidavit. But if you then do look at the budget, you see that those numbers are also different. Even the $3,045,000 looks like it's different than the profit reserve, which was shown on the budget, which was, I think, around 3.1 or 3.2 million. And while the document may have been created in 2019, the document is showing line items from the original budget and then showing how the original budget changed up into 2019. So those original budget numbers are really the budget numbers as of 2016 when the lien law affidavit is filed. So it was materially false, requiring the subordination penalty and putting the mechanics lieners in first position. Second, there's ample evidence of a material modification. One, like I said, the profit ended up being charged against the principal, reducing the net sum to the contractors. Two, it's an express condition precedent in the building facility agreement that all of the mezzanine funds get exhausted before any cent of that building facility gets dispersed to the contractors. There's no evidence that that took place, and in fact, there's if you just look at the numbers, the math doesn't add up. There was supposed to be $45 million in mezzanine financing applied first to the contractors, and then $108 million, according to the Section 22 affidavit, that would get paid out. Gilbane was the construction manager. They were only paid $93 million on about $108 million worth of work. So if there's $45 million supposed to be paid up front, and then the bank is saying there's $108 million in principal that it's seeking to foreclose, something doesn't add up there, and the natural conclusion is that the mezzanine funds were not dispersed as an express condition precedent, and if they weren't, that's a material modification of the building facility agreement that wasn't filed and that requires the subordination penalty. I think I would just reiterate that it's the plaintiff's burden in the first instance to prove the validity of the mortgage. There's obviously a gaping anomaly, as the lower court pointed out, that didn't take place.
Well, counsel, he does say that if, we're looking at, there's an affidavit, and then there's a response, and there's a reply, and then there's a surreply. So he says really everybody gets to respond to everyone else's claims here.
Well, to consider the evidence on reply is in the sound discretion of the trial court. So if the trial court wants to consider some evidence on reply for a certain purpose, it can, and this court's review of that would be on an abuse of discretion. So there hasn't been that showing in the briefing we would submit, and I think that it bears noting that it's not just that the bank didn't prove its prima facie case. Yes, the bank's motion should be denied, but we submit that our cross motion should also be granted. There's dispositive facts that are undisputed that weigh in our favor. There has to be a valid mortgageable interest at the point of execution in order to have a valid mortgage. That's not present here, and so the Gilbane liens and the other mechanics liens cannot be foreclosed. There's no issue on that fact. Second, the lien law affidavit did contain material falsities and was materially modified. The bank knew of that. They must have known of that. As I've stated, they were the last ones who had possession of the Section 22 affidavit per Exhibit 105 when they submitted it to the closing agent. So they were aware of what was in that Section 22 affidavit, and the Court of Appeals in Nanuet said the bank's role is a responsible one. You don't just get to say we're indifferent, we don't know. you have to actually look and read, and if it's your loan, you should understand if there's something wrong in that affidavit. So we submit the lower court at least erred in saying that we didn't prove a knowing violation because the knowledge is evident in the documents in itself. If there are no other questions, I'll yield to my colleagues.
Thank you.
Good afternoon, Your Honors. Timothy McColgan on behalf of U.S. Crane and Rigging. May it please the court. The only thing I would add to counsel's statements is that there's been no discovery in this case. And it's clear there's numerous questions of fact with respect to the lien law affidavit and with respect to whether the mortgage is void ab initio because there was no bona fide encumbrance or status. They simply did not own the property. So given the numerous questions of fact, we believe that there are facts that not disclosed which would support U.S. Crane and Rigging's counterclaim, and therefore, at the very least, discovery should commence. Thank you.
Thank you.
Your Honors, Gary Rubin, Venable, representing Permis de Lisa. I concur with what Mr. McColgan just said to the court. There has been no discovery in the case, as strange as that might seem. The summary judgment motion was filed by the bank quite some time ago, and there have been various reasons for the discovery not proceeding. The bank has produced some documents. Permis de Lisa has produced some documents. Most parties have produced no documents yet, and there have been no depositions in the case. And when we look at the budget, that page 2700 in the record, which is very difficult to even read, to try to figure out what it means and who knew what about the $10 million original budget listed in that document is virtually impossible now, based on what we have, what we know now. Who knew what when? We haven't had discovery on any of that. So this point is made at the very end of our brief, and I just wanted to reiterate that.
Thank you.
Thank you.
I think you said that you wouldn't. Right.
Unless the court has any questions.
Thank you.
Your Honor, there's been no challenge to the fact that these mortgages were, apart from this idea about the timing, there's been no challenge to the fact that the mortgages were issued, that Gilbane, by its own admission, was paid over $80 million in connection with this project through the mortgage financing. So for them to come in here and take the position that there's no mortgage from our perspective.
You know, in these cases, there's always a mortgage. That's just the beginning of it.
That's correct, Your Honor.
One has to establish the prima facie case. I mean, that's the way foreclosures go.
That's correct. And we're not seeking to foreclose the borrower by these motions. The only issues here, and I think that the lower court got a little bit muddled in its decision, is the priority of the mechanic lien contractors and the mortgage.
Right, I understand that this is the
so
lien.
with respect to the lien law affidavit, I already addressed the discrepancy between the miscellaneous closing adjustment line item in the budget and the consideration to be paid item that was in the lien law affidavit, paragraph 5. $150,000 difference. We think it's not comparable, it's apples and oranges, but that would be 0.092% of the $162 million amount of the mortgage. That's not material enough to constitute a basis for holding that we lose our priority. There's no question about that.
Is the affidavit clear about who would provide the financing?
I'm sorry, Your Honor?
Is the affidavit clear about where the financing would come from?
Yes, the affidavit goes to the building loan agreement, the building facility agreement, and is solely for the purpose of discussing how much funding is available to the contractors under that. It states that $108 million of funding was available under the building facility agreement to pay the contractors. None of the arguments that they've made about the line item for closing miscellaneous adjustments, about the $10,300,000 profit reserve line for the lender, none of those things
are alleged to have reduced the $108 million that was stated to be available to fund the construction project. And therefore, there's no basis for anybody to claim that the mortgage should be subordinated. The profit reserve line, to the extent that that's talking about profits that would be earned on the mortgage through the life of the project, that's discernible to anybody who would have gone in 2016 and looked at the building facility agreement. Permis de Lisa, in their papers, does this calculation where they say, we looked at the building facility agreement, we figured out that they would have earned $13.3 million in profits over the life of the loan from that. That should have been disclosed. Your Honors, the reason the building facility agreement is recorded along with the affidavit is because you can't calculate how much interest ultimately might be paid on a loan on a complex construction project like this. But what you can do is you can look at the interest payment provisions and you can do a calculation to see how the interest is charged and make a decision. Am I going to participate in this project? The fact that Permis de Lisa did that calculation now shows they should have done that calculation, could have done that calculation when they entered into the project. It's just not a valid argument. They made an argument that the lien law affidavit wasn't filed with the building facility agreement. There's no proof of that. But if you look at the affidavit from Kristen Bellany from Kensington Vanguard, she attests that they retrieved it from the county clerk's office. The executed lien law affidavit is appended to the back of the mortgage. That's at a record 2077 to 2078. They make arguments about the notice of lending. That's a separate document that totals the amount of the building facility agreement and the project facility agreement, $174 million. There was another $12 million in financing under the project facility in addition to the building facility. The fact that that document has a different number doesn't have any effect on the validity of the lien law affidavit, because the lien law affidavit is only supposed to disclose funding available under the building facility. It accurately disclosed that. They also argued that the project facility agreement should be treated as a building facility agreement and that it should have been recorded at the time that the loans were originated. That's just not the case, because if you look at the project facility agreement, you'll see that it specifically says it's not being used to pay hard construction costs, demolition costs, any of that stuff, and therefore under the lien law, it's not supposed to be recorded. It's not a building loan agreement. If your honors have any further questions, I'm happy to answer them.
Thank you.
Thank you.
Thank you all. Mayor Estates versus Century 21. You've left something there, counsel? I think that's yours.
Good afternoon. May it please the court. My name is Evan Krennick, and I'm here today on behalf of the appellant, the tenant in this landlord-tenant dispute. I think the dispositive document here is on pages 87 to 90 of the record. That is the revised and restated demand and notice for all unpaid rent. And what's critical about that document...
What difference does it make, counsel, that there is this second predicate notice where defendant didn't object to the original notice and, in fact, acknowledged that the lease was terminated? So what difference does it make that there was a second predicate notice?
Well, the story doesn't end there. I think the landlord decided to write a new chapter in the book, and we have to read the entire book to get...
Well, in that second book, as you... the second chapter, the second book, whatever you want to call it, he reiterates that the tenant had terminated on June 21st, I don't recall the date, whatever the date was, and that he refers to the Article 17, he, you know, the notice to cure, he reiterates everything that was already established. So why would that, you know, extend the term of the lease?
But it doesn't
I don't
extend the term of the lease. I wouldn't suggest it does, and it doesn't extend the landlord.
Revive. Why does it revive?
It only
the lease?
extends the cure date. And under the lease, the letter of credit provision, and whether they anticipated this or didn't, I can't speak to, looks at 2 dates. Is there a default under the lease that extends beyond any relevant cure date versus a termination of the lease? Those are the 2 dates you look at for that purposes of the lease, and that's all we have to do. So when they decided to send a new notice of demand and extend the cure date later, that has consequences for other things for sure. But the consequences it has for the letter of credit is that it now made the cure date well beyond the termination of the lease expiration date. So under that provision of the lease, there's only 2 relevant dates. They can't just say, we didn't mean it, we want to take it back, I don't want to do it anymore, I didn't realize it was going to impact the letter of credit. Whatever reason they did, it has consequences. It's a real notice, it went out, and it extended the cure date beyond the end of the lease. And again, under the terms of Article 91, that's all that we have to look at is 2 dates. And they created this own problem for themselves by extending the cure date. Now, they did it for a good reason. They didn't do it by happenstance. They did it because the April notice of cure was deficient. And that's in the record, and that's also, I don't think you have to get to that issue, because I think once you have an extended cure date and you compare it to the end of the lease, case closed.
So
they don't get the letter of credit.
This is the issue that I have. Now you say that your acknowledgement of the lease termination by letter that you sent to the landlord on June 7th, and you were very happy about that because you had another lease that you wanted to renew, and because of a certain provision in the lease that is now, we're fighting over whether or not it's terminated or not, the 456 lease, you say, well, you know, now that that lease is terminated, that provision in that lease is no longer an impediment for us to renew this other lease. So basically, you're saying.
True. What you say is true. We were very, I mean, I'm not going to quibble with you. We did say purported lease termination. We reserved our rights. We didn't waive any rights. But I understand what you're saying. On June 7th, when we wrote that, they terminated the lease, and we took advantage of that. We accepted that. But then they decided next year to say, here's another notice of cure period. We didn't know they were going to do that in June 7th, but they created this problem. If the story ended,
but when they sent that second notice, the lease had already been terminated in June of 2021, and it would have terminated by operation of law, right?
The landlord-tenant.
In January.
Yes. The landlord-tenant is crossing the I's and crossing the T's and dotting the I's, and whether they needed to send that second notice of cure letter or not, they did. It extended the cure period. And the letter of credit provision doesn't talk about lease termination. It talks about when's the end of the cure period. Is the lease terminated because your default went beyond any applicable cure period? Well, applying the plain,
But doesn't a cure period assume that there is a actual lease? And if you have already acknowledged that the lease is terminated and quite some time has already passed.
I would not concede we acknowledge that, but even so,
I didn't hear what you said.
I would not concede that we acknowledge that, but I understand the point. The language is clear. It's unambiguous. I mean, this is a lease provision says, Article 9, it says what it says. It doesn't assume or imply anything. We have a cure period that's later than the end of the lease.
But it's in a lease that is terminated. It doesn't exist.
But they sent it. So what was the point of them sending? Does it have no consequences? Does it have no meaning? Does it not have any effect on anybody? They could just send it, and it doesn't impact any of the rights of the parties. They sent this very formal demand. It's their basis.
So you're saying if there was a letter that was in somebody's office and it got lost in between the cracks, and some new person comes and works at the office and sees a letter with a stamp and throws it in the mail 10 years later, that revives the lease?
Well, That's not the fact.
Answer my question. Would that revive the lease?
I would have a hard time arguing that facts would revive the lease.
So the difference is 9 years? Is that
Difference is
that
that-
where you're right and and the court is wrong?
I would argue that the letter here was sent for a particular reason at a particular period of time, and the lease provisions are unambiguous, and it doesn't allow for the court to decide in these particular facts that it has no meaning or no impact on the right to the parties when they chose to send that letter and extend the cure period.
Thank you.
Force them to do that. They chose to do that.
Thank you.
Thank you very much.
Good afternoon, Your Honors, and may it please the Court. Alexander Likianis of Holland and Knight for the respondents. I think the panel is properly...
Well, I don't know that you should say that. We
Yeah.
raised questions is what we did.
Okay, well...
So I have to ask you, why did you send this second letter? And more importantly, there is another letter that went out. So what's the impact of that? What should the impact of that be? Where the purpose is to extend the time.
So the purpose of that second notice relates back to a decision that Justice Borak issued in the related case on April 18th, 2022. And as Your Honors know, there are these two cases, and there is some interplay between these two leases, between the 456 lease and the retail lease. And in that prior holding, Justice Borak said that certain earlier notices, not
Yes,
the
I
April-
understand that, but not this one. This one wasn't done yet, but you were a little worried, is that it?
Yeah,
That,
so-
oh, no, we might not be right either?
That's correct. There was a statement that
Is
Justice Borak
is there a
made in his
comparison
decision.
of the two that would have led to believing that this one also, because the other one wasn't, this one was?
Right,
Not
Justice-
accurate?
Right, so Justice Borak made the statement at paragraph 4 of his April 18th, 2022 decision that nothing in this decision shall prevent the plaintiffs from serving proper notices of default for any default that remains outstanding as none have been waived. Now again, at the time that this second notice was served, it was a year after the lease had been terminated, after the tenant had acknowledged a total of 6 times in writing between the June 7th letter and their initial answer that the lease had been terminated. They moved out, they were gone. It was a year later. Nevertheless, we got this decision that related to certain earlier notices. So the client at that time decided that it would be prudent to send an additional notice that would make clear that they weren't in any way waiving the sums that were due under the 456 lease through the date of termination. And specifically, at page 87 of the record, they made sure to note, to make sure they didn't waive any arguments, to make sure that they didn't, that there couldn't be an argument that there was a revival of the lease. It states specifically, please take further notice that tenant was a former tenant at the premises and remained in possession thereof pursuant to a written lease agreement dated June 2nd, 2010, by and between landlord and tenant for the period ending on June 7th, 2021. This is a year later. There is no possible way that Century 21, a sophisticated party represented by sophisticated counsel, could understand this notice to be restoring a lease that was terminated a year earlier. They did this, again, simply to preserve their rights, simply to make sure that there could be no argument at any time later on that they somehow waived the termination or revived this lease.
Huh.
I'm sorry?
That didn't work.
Well,
Hindsight.
well,
In any case.
Well, I mean, they can make any argument they want, Your Honor, but it doesn't have any merit because they specifically have this language in the notice, and specifically it was a demand for money only. There was no demand for rent. They didn't take any additional steps to revive any kind of landlord-tenant relationship. The relationship had been terminated for that lease for a year at that point. So the argument at this point is simply without merit. And I also note that my adversary basically has walked away from every other argument he's made in his brief regarding supposed defects in the notices because they're all without merit. And one other point I'd like to just bring up to clarify for the record is that we're here on a motion to dismiss a declaratory judgment cause of action. And as this court held just a couple of years ago in General Insurance versus Pyquan, on a motion to dismiss a declaratory judgment action for failure to state a cause of action, The only question is whether a proper case is presented for invoking the jurisdiction of the court to make a declaratory judgment and not whether the plaintiff is entitled to a favorable determination. So we're talking about the merits, but even before that, procedurally, all we're talking about is whether there's a proper case for a declaratory judgment here. We say that we're entitled to a letter of credit under Article 91 of the lease. They dispute it. There's a justiciable controversy, and there's a proper controversy under CPLR 3001. And I'd also like to just note for the record, although it's not in the record, but just 2 days ago, we argued summary judgment in front of Justice Borak.
Dehors the record, so really.
Okay,
Thank you.
Okay, so so otherwise, Your Honor, I don't have any other responses to my adversary's arguments, and I'd like to just rest on my brief at this time. Thank you.
Thank you.
I don't waive any of the other arguments, and I'll briefly talk about the April notice as being deficient, which is an alternative argument to the later notice. The notice has to provide what the breach is, what you have to do to cure it, when you have to cure it by, and what happens if you don't. You could read that April notice 27 times. You're not going to find that last portion satisfied. It tells us what the breach is. It tells us we have to pay the money. It tells us when we have to pay the money. It does not tell us what happens if we don't pay the money. And you could read it over and over again. It's not there. And then they confuse it because in the May notice, and I have the record sites if the court's interested, they characterize the April letter as saying, in the April letter, we told you if you didn't pay, we were going to cancel the lease. That's pure fiction because nothing in the April letter says that. So
Are you referring to the April 16th notice? Because there's one April 16th, and when I read it, I thought everything was there, you know, with respect to the default provision, how much was owed, you know, and the consequences of what would happen if a default was not cured. April 16th,
that's the letter,
2021.
and the record site is 198, I believe, and I would simply disagree that it says what would happen if you don't cure the default. It says landlord reserves all rights and remedies. That is not sufficient. What they do is they cite to Article 17 of the lease, but not in that paragraph, not in the remedies paragraph. They cite to Article 17 of the lease in the notice paragraph saying, we're giving you notice pursuant to Article 78 that you need to cure. But when they get to the remedy, what happens if you don't cure? All they say is we reserve all rights and remedies. And the cases of Legion, that's not sufficient. That's not specific enough. That's not unequivocal enough.
Counsel, did your June 7th letter reject the notice indicating these arguments that you're now making before the court?
I don't believe there's anything, we don't think we rejected it. I don't think we accepted it. We called it a purported notice of termination and took it for what it's worth. But again, to circle back, the issue here.
You said yay.
Well, listen, sometimes you get a gift.
You acknowledge the lease was terminated in your letter.
Sometimes you get a gift that just keeps on giving. And they wanted to give us a gift of terminating, then they wanted to give us a gift later on of extending the cure period.
They didn't.
That's their.
Thank you.
This has to do with the letter of credit.
I think we understand the arguments.
Okay.
Thank you, counsel. Thank you both.
Thank you very much.
People versus Christopher Cordero.
Good afternoon. May it please the court, Laura McFeely for Mr. Christopher Cordero. I want to note a minor correction to our brief, which represented Mr. Cordero as finished with probation. He actually has a few months left, and then he'll be done. We asked this court to dismiss the indictment. First, there is no case in New York that we can find supporting felony drug possession for alleged conduct this minimal. The weight of the evidence...
For being a lookout?
I'm sorry, I didn't hear.
For being a lookout to a drug deal?
Yes, for being a lookout, that's correct. Under the lookout theory, the conduct has to be sufficiently calculated and direct, and the weight of the evidence does not support that. In Johnson, which we cited in our brief, the defendant verbally directed the undercover to the seller, and this court found that legally insufficient, which obviously is a higher bar, even though it involved much more substantial conduct. Here, the undercover testified that Mr. Cordero moved, quote, a little bit closer, end quote, to the seller while saying, the cops are here. Even if that single witness is credible, that's not sufficiently calculated and direct to constitute accomplice liability.
But that act accomplished two things. It it advised the drug sellers and buyer that there were cops in the area and could be found out. And two, it obstructed the view of the drug transaction. So those were two acts, one verbal, one physical. Why is that not enough?
Because there's nothing to indicate that that wasn't just a spontaneous observation of a police car driving by. There's nothing to indicate that he was.
Why would you have to be worried about a police car driving by?
And
if
why do you have
weren't
to announce it?
engaged in any illegal, illicit activity?
I mean, just stepping back for a moment with the context, this is a group of drug addicts near a methadone clinic. Some of them are selling drugs, yes, although our position is that our client did not know that.
Well, some of them selling were with your client.
That's, yeah, his acquaintance, but he didn't know that. He needs to, the prosecution has to prove that he knowingly and unlawfully aided the drug transaction, and there's just not enough here to indicate that it wasn't.
You're saying that a jury, hearing that these men who are standing in front of a methadone clinic, which implies that they are drug users and certainly familiar with the entire drug world and how it operates, that he's standing while a drug transaction is happening in front of him and he doesn't know what's happening. A jury was not entitled to disbelieve that theory?
I want to correct something I said because I think I may have misleaded the court into thinking that the transaction happened immediately in front of the methadone clinic, so I just want to set that straight. It was near a methadone clinic, but not directly in front.
Right,
And
it was closer to the Dunkin' Donuts, right?
right.
Okay.
But still, just because he's a drug user doesn't mean he's assisting this particular drug transaction. There's just not enough here to show that he's assisting this drug transaction.
What about the fact that he calls this individual 4 times in the hour preceding the drug sale? Anything that would not suggest to a jury that he was involved with this individual in drug selling and was there to conclude the sale?
Sure. I think that actually one of the cases that respondent cited in the response brief was helpful on this point. Hawkins, which was a Court of Appeals case, there was an in-person conversation with the defendant and co-defendants in the middle of an extended drug transaction. The undercover bought marijuana, requested cocaine. All of the co-defendants spoke to each other, and then the defendant was a lookout on the corner looking in all cardinal directions while his co-defendant went and retrieved the cocaine and came back. And in that situation, it was reasonable for the jury to infer that that conversation in the middle concerned the drugs. But here, there's phone calls. First of all, from the frequency of the calls, we don't actually know from the extraction, but it appears that they're missed calls. But the more important point is that
It was just a coincidence that they just run into each other on the street. It's just a coincidence.
they attend the same methadone clinic.
4 phone calls. They just happen to bump into each other, and then certainly when they get arrested, they run into each other. All of these are coincidences.
They frequent the same methadone clinic, and the more important point is that it's not reasonable to infer that these phone calls are, a drug transaction or a conversation about drugs or furthering this drug transaction when it's, hours before they've even met up. There's no indication that anybody involved knew that there would be a drug sale later that day.
This is a weight of the evidence issue. So all of these would go to you're arguing obviously they wouldn't, but all of these would add up before the jury with regard to weight of the evidence.
I'm just saying there's not enough there. I was unable to find any case that supported felony drug transaction for anything this minimal. And I think the weakness of the evidence was compounded by the Brady violation in this case.
But I'll let you finish on the Brady violation on rebuttal, okay?
Thank you.
May it please the court, David Gagne for the people. My adversary wants to focus on just a single moment in time rather than the defendant's entire course of conduct. And what the totality of the evidence shows is that the defendant served as a lookout during the sale of fentanyl-laced heroin to the undercover. So as Justice Manzanet already—
Well, it doesn't matter what the heroin or what the subject was, right?
That's right, yeah.
We're talking about the placement of the individuals, the conversation, what actions this particular individual took in relation to the other, and whether that supported a felony conviction as an accomplice.
Yes, that's right. And what the defendant did was he alerted the seller to the presence of the police car. He said, "The cops are here. The cops are here." He stood in front of the seller to shield him from view of the police. And in addition to that, we have the defendant's actions in the lead up to the drug sale, which show that he had a community of purpose with the accomplices to sell the drugs. The defendant called the seller 4 times in the span of 5 minutes and in the hour preceding the drug sale. The defendant walked out of the Dunkin' Donuts with the seller. The defendant was standing next to the seller when the seller was discussing the drug sale with the undercover. The defendant walked.
Doesn't that all lead to the fact that they were friends? They met one another in the methadone clinic. They were friends. He calls him because he's going to hang out with him. He doesn't know what he's going to be doing. Does that mean that because there are 2 people who are drug users, that every time they get together, it means that they're there for a drug transaction?
I think certainly when you consider the fact that there's the seller, there's the buyer, and then there's the 2 steerers who brought the buyer to the seller, and then you have the defendant. That is evidence that he was a part of this drug transaction. And that by itself wouldn't be enough. I don't dispute that. But then we have the fact that he did in fact say, "The cops are here, the cops are here," and then he moved in front of him. That all together is what proves that the defendant was guilty.
Can you address the Brady violation?
Yes, there was no Brady violation in this case for the simple reason that the statement was disclosed to the defense counsel just 2 days after the statement was made and about 15 months before the trial.
Is there any requirement, as the defense seems to argue, that on the people that they not take a plea of a co-defendant in an instance where, such as this, where there is a statement that can arguably be Brady?
No, there's nothing suggesting that. There's no obligation on the people, as my adversary suggests, to then go and investigate that statement. What their obligation to do is to disclose it to the defense counsel. The people had a good faith basis for believing that the defendant had in fact been a lookout. They had the officer's testimony in the grand jury. They had the co-defendant, Bruno, who had already pled guilty and implicated all of the defendants.
And the statement was that he was just standing there, correct?
So the full statement was that he didn't want to allocate to the co-defendants because he was afraid of them and they were in the courtroom, and that the defendant was just standing there, which admittedly is exculpatory. And so the prosecution did have the responsibility to disclose it, and they did. And I would also just point out that that statement is not all that inconsistent with the people's evidence. As I've already mentioned, the defendant was a lookout. He wasn't the one handling the drugs. He wasn't the one handling the money.
So that was a true statement. He was just standing there. He happened to also say the police are nearby, but he just stood there.
No, it was not a true statement. All I'm saying is, for someone who's perhaps not
Did
familiar
anybody
with
challenge that? It was in his allocution, wasn't it?
I'm sorry.
Wasn't that in the co-defendant's allocution?
What was in the co-defendant's allocution?
He was just standing there. That came out in court, didn't it? That statement.
That
made
statement
in
was
court.
made by the co-defendant's counsel during a bench conference, yes.
But during the allocution, the co-defendant inculpated the defendant, correct?
That's right, yes.
Allocated to the acting in concert with the defendant, correct?
That's right, that's right.
Now, in terms of this being Brady, it's Brady, but speak to whether, in fact, there was any violation of Brady.
There was no violation of Brady. Again, in order for there to be a Brady violation, the people have to suppress the exculpatory material. They did not do that. They disclosed it 2 days after the fact, 15 months before trial. The defense had every opportunity to make whatever use of it.
I'll let you go in a minute, but so the defense attorney is telling the judge at the bench the co-defendant was just standing there, and then he's told in order to plea he has to allocute that he was involved, and then the defendant says he was involved, he was doing this, and then the information is turned over. Was there anything inappropriate in requiring, after the defense attorney has already said, he says the guy was just standing there, requiring him to have to make that statement in order to accept a plea, in order to...
No, there was nothing inappropriate about that. The court can impose reasonable conditions on a defendant before accepting his plea. And one such reasonable condition is requiring the defendant to allocute as the crime actually occurred.
Thank you.
Thank you.
Brady evidence must be disclosed in time for the defense to use it effectively. And here, the prosecutor neutralized this very powerful exculpatory statement through a gratuitous plea allocution.
That statement could still be used if your client chose to go to trial.
And then he would be impeached on cross using a formal in-court statement.
But that's the way it rolls, right? So you could, but it didn't prevent you from using it.
It significantly weakens the defense case.
They don't have an obligation to give you a statement in the way best usable to you, just that they give it to you in a timely fashion. And how you use it and when you use it, that's up to you, right?
And what would make it a violation is if you didn't receive it in a timely fashion and you received the statement in a timely fashion.
15 months before.
I'm sorry, I didn't hear that.
15 months before trial.
But after the prosecutor had rushed forward with the plea allocution that would neutralize the
What do you
statement.
mean
Before
rushed?
sentence,
What do you mean
right?
rushed?
You could have adjourned the proceedings. I mean, the prosecutor...
First of all, the prosecutor is not empowered to rush through with a plea allocution. That's up to the court to determine that this is an appropriate time to take a plea.
What matters is that in court, a prosecutor heard this statement that Mr. Cordero had not done anything and was just standing there, and so Mr. Murray didn't want to plead, knew that when that fact comes to light in the middle of a prosecution, somebody needed to do something about it. Either defense counsel, because he has the duty to his client, and he had left the court in the middle of the proceeding.
Well, I don't think he did anything wrong. He was done. His case had been adjourned. He left. I mean, his client, I don't know if his client was incarcerated. I don't think so. His client also could have left the courtroom, but remained there.
It was not, the proceedings were not actually adjourned, and it was not precisely clear when the lawyer left the room.
But that doesn't really matter, right? Because here, your client had counsel, his case had been heard, the case had been adjourned. Proceedings for your client were over at that point. The fact that a co-defendant's case gets called again and they take a plea, there's nothing wrong with that. The prosecutor didn't do anything wrong, and the court didn't do anything wrong by allowing that plea to be entered.
But there's no dispute that it was Mr. Cordero's proceeding that morning, and
You're saying it's unclear that the case was adjourned? Is that what you're saying?
The case was not officially adjourned.
What about his case? He was already addressed by his, I mean, the court wouldn't just let an attorney walk off if their client had...
It's a multi-defendant case wherein the issues pertaining to your client had already been solidified, meaning that your client had already decided not to take the offer, and defense counsel received an adjourn date to come back. Thereafter, defense counsel left. The court's empowered now to move on with the other defendant's case independently of what transpired with your client.
And the transcript
Is there any question about that?
Well, the respondent's position is that we need to look at transcripts to figure out exactly when the right to counsel, has detached, and that's just not what our law is. And it's
The
not
transcript is very clear.
March
We have
14th.
the transcript.
right, but it's not even clear that Mr. Sullivan's still in the room at the time that the court decides on March 12th.
Yes.
It is.
But
It
in
is.
any case, what you're saying is that the problem happens because the prosecutor had an obligation to stop. We have the court that's there. We have the defense attorney who's there. Why is it the prosecutor's obligation to say, I have to stop this so that I can turn over this Brady material that I heard? Why isn't it for the defense attorney to say, I'm looking after my client, and he's going to take the plea right now?
When you say defense attorney, you mean the co-defendant's defense?
Yes, I'm sorry, the co-defendant's defense attorney.
I mean, the co-defendant's defense attorney owes nothing towards
Exactly.
our client, but the prosecutor has a duty to do justice.
But the prosecutor can't stop this. If the defense attorney could say, no, I want my client, he's got the deal now, he's ready right now. And he did. That's what happened. He took the deal he got. Anyway, I've allowed much more time. Anything more?
An adjournment would have, there was no need to rush forward with the plea, is I suppose the point, that an adjournment would not have harmed anybody, and it would have allowed defense counsel or Mr. Cordero a significant opportunity to, for example, ask the prosecutor to take out the boilerplate.
There's no way for you to know that. There's no way for you to know whether the co-defendant's offer would have been taken off the table. So you cannot say that. The co-defendant had an opportunity to take the plea that he wanted on that day, and he did. Adjourning it may have inured to the detriment to that defendant.
Well, if that's your argument, you can make it. That's not what we're saying, but.
Yeah.
Thank you. Can you wrap up in 30 seconds? Because I've given you much time over the 2 minutes.
I apologize. I just think stepping back, this in our system where due process is paramount, this just can't be how things work, that a prosecutor hears an exculpatory statement from the central person in the drug transaction who knows what's happening on the scene, and that.
Thank you.
Yeah, okay, thank you. We ask the court to dismiss the indictment.
Both. Thank you all. Chetrit versus HPS Investment.
Good afternoon, Your Honors.
Good afternoon.
Please the court, Chris Sullivan for appellant Jacob Chetrit, it's pronounced, Your Honor. My colleague John Letty making his first appearance on the court today.
Welcome.
This appeal concerns an assignment in lieu transaction between Chetrit and HPS that took place last year with respect to the ownership of an office building at 850 3rd Avenue. HPS held mortgage and mezzanine loans against the property and received by assignment from Chetrit the ownership of the LLC that held title to the property. Prior to the conclusion of the transaction, HPS tried to get Chetrit to sign a transfer tax return pertaining to the transaction that falsely reflected the $100 million mezzanine loan as consideration for the transfer, and not also the $220 million mortgage loan.
So this was a settlement agreement, right? There was this settlement payment that had to be made.
Yeah,
That's what the requirement was. I mean, this transfer tax, no one said, well, they may have said it at some point, but there was no written itemization of all of the different taxes or transfer tax and the exact amount and an agreement as to the exact amount that would be. None of that was in writing. It could have been, but it wasn't.
No, Your Honor, no to all 3 points. Okay, this was not a settlement agreement, it was a contract.
Was there a settlement payment?
There was the word
Okay, so let me finish my
payment.
question. Let me finish my question then. There is a settlement payment that was made, and in advance of the settlement payment, there was nothing in writing identifying what would be paid, how it would be paid. It was a settlement payment. There were oral agreements that I'm going to pay the entire transfer tax. That was nowhere in writing. And then the settlement payment is made.
Your Honor, it's
and
not
then,
correct.
No? Okay,
correct.
tell me how I'm
The
wrong.
draft
I'd like him
agreement
to tell
doesn't
me how
count,
I'm
though.
wrong.
You see, I know you're going to go to that, but if you wanted that draft to be a part of the terms of this contract, then you had to include it in the writing, and you didn't.
And not have a broad release that released everything prior to this agreement.
Just without going to the draft, Your Honor, but one interesting point about the draft, it uses the word settlement payment to describe the entire payment of $37.2 million. Same words.
Even if that's true, yeah.
Yeah, if I can, Your Honor,
Yes.
when I say it's not a settlement agreement, this was a contract under the carry guarantee that Chetrit gave. It's a non-recourse loan. The only personal liability was his. He gets released if he gives title, and he makes what the carry guarantee calls a required payment. It's defined and it's itemized in the carry guarantee. Right down, and the first item is transfer tax. Transfer tax with transfer tax returns. So the only evidence in the record is in the verified complaint. This was a pre-answer motion, and in Chetrit's affidavit, in which he says HPS and Chicago Title itemized the required payment by category as per the carry guarantee, and they came up with $37.2 million, and $10.4 million of that was a transfer tax on the proper consideration of $320 million. Okay, that's set forth. That's not a settlement. You can't settle a tax payment to the city of New York. It's a
Call
payment
it
to a
what
third
you want.
party.
Well, that, you can call that whatever you want. The agreement that you both entered is called a settlement agreement.
Well,
That's why I'm using that word.
No, I understand.
And that's an amount of money that was agreed to be paid in order to move on to the next amount of money.
And it's not correct, but it's a little bit nuanced, if I can, Your Honor. And this was a point that Justice Ostrager didn't spend a lot of time in a page and a half, but he focused on it. Okay, so the carry guarantee says, here are 10 payments you must make. Okay, and HPS and Chicago Title calculates them at 37.2. The only evidence in the record, verified complaint, Chetrit affidavit, is that there was a dispute over 2 of the 10 items, a reserve account, and Chetrit saying you took too long and interest accrued because they had an agreed upon default. And so they compromised those items only from 37.2 to 35.4. That's the evidence in the record. There's nothing to contradict it in any way. But what Justice Ostrager did not focus on is that there were 2 contracts at the closing. There was a tender agreement, Your Honor just referred to it, that has the words settlement payment after $35.4 million. But then there was a tender satisfaction agreement at the end in which HPS admits in writing that they received $35.4 million in respect of the required payment as calculated and agreed by HPS. How is that not tethered to the required payment? In respect of the required payment. Justice Ostrager never looked at the words in the tender satisfaction agreement, but it goes even further than that. It acknowledges that Chetrit has complied with all of the conditions in the carry guarantee. The first condition is payment in full of the transfer tax on the full consideration. That's $10.4 million. That's an admission that it's $10.4 million. The second condition, payment to the title company, $1.1 million for an owner's policy. You can't settle a payment to a third party. What Justice Ostrager didn't consider is that the so-called settlement payment referred to in the tender agreement can contain definite itemized terms that cannot be varied. He never looked at that. Okay, but that is, he just acted like the word settlement payment was checkmate.
You said
it's not.
That it can contain itemized payments. Did it actually?
But this is the point that was made earlier, Your Honor, that all of the drafts up to the final draft had an itemization schedule of $37.2 million.
Which was then removed
with
the final agreement.
Agreed. No.
It didn't exist anymore.
Correct. Just parenthetically and somewhat ironically, all the drafts use the word settlement payment to describe 100 cents on the dollar. So how meaningful is the word settlement payment? But leaving that aside, when they got to the final version, yes, we allege it in the complaint. HPS said to Chetrit, we're dropping the itemized calculation. Okay. Does that mean that they can go out after the closing's is over and use his name to file a false tax return? Which is what they did. They used his name to file a false tax return.
What makes it a false?
They calculated it on something else. They calculated it on a different basis, but what makes it false?
Yeah.
I'm sorry.
Has there been some determination, some letter, some notice by the state or city or federal tax authorities saying, you know, the taxes that were paid on this are insufficient?
Not yet, Your Honor. But why should Chetrit have to worry about that notice coming in the mail? Why? The answer to your question, Your Honor.
Well, I don't know why, but my question is, it's removed it's removed and it's not part of the final agreement. And there is a broad release here that says anything prior to that
To the
agreement.
closing. Anything prior to the closing. Okay, this took place after the closing. A cause of action for breach of contract accrues when the contract is breached. When was the contract breached? They made a contract in the tender satisfaction agreement to file his transfer tax return, to pay his transfer tax, and they didn't. They changed it. They filed a different transfer tax return and a different transfer tax. They breached the contract after the closing, after the date of the release. There's no bar under the release. Quite the opposite. The release is specifically limited by its terms to events up to and through the date. There's no future claims included here. So the release isn't an issue at all. And the term settlement of payment is at best ambiguous because you have two contracts. One says 35.4 million settlement payment. The other says, I admit 35.4 million in respect of the required payment as calculated and agreed. That's not ambiguous. Where's the untethered? Untethered is the word Justice Ostrager used. How's it untethered if it's in respect of the required payment? And if you've admitted the two of the items in the calculation, the transfer tax and the payment to the title company, are fixed because they go to third parties, then isn't there an ambiguity on a pre-answer motion, Your Honor? Chetrit was defrauded. He got mugged in an alley by a lawyer with a sharp pen.
Thank you.
Basically, we're saying no remedy. He
Thank
does
you.
have a remedy.
Thank you.
Thank you, Your Honors.
Good afternoon. Sorry. Janice McAvoy from Fried Frank on behalf of the respondents, HPS Investments. Really, what Chetrit's disagreement here is that he now thinks that the settlement payment was too high. The settlement agreement was an agreement. It's a contract. All settlement agreements are a contract. But this one said, and Mr. Chetrit said this in his affidavit, there was a dispute about the amounts. There were compromises. He admits in his affidavit there were disputes about the transfer tax. They couldn't agree on the number. And the number that my adversary keeps calling 37.2 million wasn't 37.2 million. It was $37,253,253 to the dollar. And what did they agree on? 35.4 million. They agreed on a compromise because they couldn't agree on the separate elements.
And counsel, if I may, let's talk about the taxes.
Specifically with respect to the taxes.
Well, I want to pose a question to you. So the taxes, they were based, well, what was paid was the outstanding balance of the loans, right?
Exactly, Your Honor.
And your client had the discretion, right, to apply the settlement payment and the cash reserves that you had, and that reduced the amount of the transfer taxes.
Exactly right, Your Honor. And in paragraph 2 of the tender agreement, which defines the settlement payment, it specifically says the settlement payment will be deposited into the debt service reserve account, collateral for the loan. Loan agreements say you can do, lender, you can do whatever you want with that collateral. But then the tender agreement itself goes on to say you can hold, liquidate, and or apply it to the debt if you want to, HPS, in its sole and absolute discretion without any adjustment, rebate, or refund in favor of guarantor. And now Chetrit is coming here saying, oh, but I want a refund. He's not entitled to that refund. They agreed to a settlement. He now says, oh, in his mind, in his heart, he was settling only on these 4 items. It wasn't 2. In his affidavit, he says it was 4. It was only on these 4 items. Just ignore what was in HPS's head. What was in my head, he says, that's what really matters. And therefore, you have to give me a refund because of this, underpayment of the transfer
And as
tax
you
returns.
indicated, this entire issue was discussed.
Absolutely.
Your side's theory of how the transfer tax could be reduced to their benefit was discussed with them. They didn't agree with you.
They did not. They did
And
not.
so they then settled on the number that they settled with you, but did not include any language that required, in the final agreement, that required the payments.
Exactly.
As he now says they must be made.
Exactly, Your Honor, and included a very broad release. And the reason that
Counsel
Justice
says the broad
Ostrander-
release doesn't apply.
because what they're trying to do is
There were two
convert-
releases.
There were two releases on the same day. First, the both broad release contained in the tender agreement itself, and then the separate general release that also released everything. What they're trying to do is convert what they agreed in the tender agreement. We waive any claim, right? And we let you apply this payment any way you wish. Well, now I'm going to complain about how you applied it. I didn't release that because that happened after. But it's in the agreement itself that says you can apply this payment any way that you want. That is
Counsel,
not.
what about the argument that he's exposed to potential tax issues because of the lesser tax that was paid?
We established in our papers by the statute, by the law, how it was properly done. In his reply papers, he says he concedes, well, even if it's not illegal. First of all, there's been no notice. This has been in the paper. The taxing authority, well familiar with Mr. Chetrit, would have gone after him if they had read about this in the paper. It's just absurd to think that he's exposed to personal liability. But by the way, that's waived. Were he ever to be exposed to personal liability, then he could sue. But it's not going to happen, and he can't sue now when he's not facing any liability. Unless there are any other further questions, Your Honors.
Thank you.
I'll be very brief, Your Honor. HPS did not have the discretion to apply the required payment to the loan. Section 3 of the tender agreement says that if Chetrit defaults in the process of the tender, if he obstructs the tender, then his payment can be put into a reserve account and used. It does not permit HPS to take his payment. And you want to know what the best proof of that is? The second time they approached Chetrit, asking him to sign a false tax return, they told him, we want to apply the required payment to reduce the debt. And he said no, because they weren't offering to reduce any of the other charges, and his title company was telling him that there was a legal issue. They came to him. Section 3 of the tender agreement says you cannot just use the money, only if there's a default, only. They contracted for the right in this agreement to use the reserve payment in a precise manner, and they didn't do that. Twice HPS tried to get Chetrit to agree. Twice he said no, so they did it behind his back. And they filed a transfer tax return that shows a consideration of $265 million, 2 weeks after the transfer for $320 million, which is the true transfer. Of course he's exposed to liability. He should have a chance to get to discovery in this case, Your Honor.
Thank you. Thank you both.